Okay, welcome to this episode, the third in our series on philosophy of law. So last time we were talking about why it was that modern positivists reject classical positivism, and in doing that, we saw what the kernel, the core of modern positivism will be. This idea that to use the language, my language, not their language, law carries deontic power. Okay, so what we need is a theory of law that explains why law doesn't merely say do it or else, but says you have a right to do it, you have a permission to do it, you are prohibited from doing it, you have an obligation not to do it, you have a duty to do it, and so on. Why the law works in terms of these concepts, rights, duties, powers, permissions, and so on. Why it is that the law has deontic power. Okay. So what I'm going to do in this episode is I'm going to talk about how Hart develops his theory and just give you the outline. It's a bit more than an outline, but not the full theory because that would take forever. But sort of a bit more than an outline of Hart's theory of positivism, Hart's positivism. Okay, so remember that classical positivism is the idea that law is a command of a sovereign attached to a sanction. Okay, now. Hart we've already seen that he's rejected this because he said that this leaves out the fact that law is normative, normative in the way that it is normative, that it has deontic power. Okay, now, so because he has this realization, his focus on law, his approach to law is different because he thinks, okay, well, law creates rights, duties, powers, permissions, and all that stuff. Well, what could do that? A simple order from someone, just someone saying, do it. That couldn't create, or do it or don't do it. That couldn't create any kind of obligation in me to do it. What kind of thing could create an obligation in me to do stuff? And the answer that he comes up with is rules. Right, so law for Hart is not a system of commands, but a system of rules. Okay, so law is to be understood as a system of rules. Now, this is important for another reason too. So one of the reasons that it's important is that rules sort of hold it. Viewing law as a system of rules seems to hold out the possibility that we're going to be able to explain the law's deontic power this way, right? Because we can say you have a right to this because there's a rule that says you have a right to it. You have an obligation to do this because there's a rule that says you have an obligation to do it, right? So it looks like it's going to hold out the possibility of explaining the law's deontic power. But also remember from last time that classical positivism had this problem with explaining areas of law like the law of wills or the law of contract, or the law of property, areas of the law that don't seem to be about commanding people to do anything. Now Hart's response to that is to say, yeah, the law is that those areas of the law are not about commands, but they are about rules. So the law of contract formation, so for example, the doctrine of offer and acceptance, okay, that's not a command, but it is a rule, right? There's a rule that says in order for there to be a binding agreement between us, one of us must make an offer and the other must accept it. That's the doctrine of offer and acceptance. That's a rule. Okay, so we could explain the law of contract as a system of rules, but we can't explain it as a system of commands. Same with the law of wills. The law of will formation contains a list of rules that you must follow if you are to create a will. We can't understand that as a series of commands, but we can understand that as a series of rules. Okay, so that's how Hart seeks to improve on classical positivism in order to develop his new theory. Okay, now there's another thing that's really important about the move from the idea that law is a command to the idea that law is about rules. And that has to do with the way that commands and rules function in our practical reason. Right now, that's a slightly obscure claim. I don't imagine that will be clear, but let me give you an example in order to bring this out. So a command we express as kind of external to us, right? So if someone commands me to do something, right, I experience that as, something external to me, telling me that I have to do something. Okay, and sometimes we experience law that way. But Hart's insight, and this I think is perhaps Hart's greatest insight, he realised that a lot of the time, law is not like that. Law is not experienced as someone telling me to do something. Law is internalized in a way that I just obey it because it's the law. I obey it because I make it a standard for my own conduct. Now, that might sound surprising to you, and when I teach this to students in person, they often think that that's wrong. They often think that law is always experienced as something that's imposed on them by the state, right? But let me give you an example that I think that is wrong. I think Hart's right about this, and let me give you an example that helps to demonstrate this. So, the question, if we were here in person, the question I would ask you to answer is, why do you, if you drive, why do you stop at red lights? Now, the standard answer that I get, there are a bunch of standard answers that I get. Why do you stop at red lights? People will say things like, well, I don't want to have a crash, right? If I go through the red light, I might have a crash, and I don't want to have a crash. People will say, well, if I go through the red light, a police officer might see me and they'll pull me over and give me a fine, or there might be a red light camera that will detect me doing this and I have to pay a fine, and I don't want to do that. Okay, and they're all this, as I say, the standard answers, and no doubt sometimes they are true, right? Sometimes that is the reason why we stop at red lights. But I then suggest to people that most of the time that's not the reason why you stop at red lights. And one of the reasons, just as an aside here, one of the reasons I like this is because I think there's a sense in which this is the first moment in a course like this that we really start doing philosophy. I mean, we start doing real philosophy. Well, what do I mean by that? I think this kind of real philosophy is when someone starts challenging you about your own beliefs, right? It's like, that's when philosophy gets really interesting, at any rate. Because what I do to the students is I say, you tell me what you think you do, and I'll tell you that you're wrong. You're wrong about what you do, right? I'm not saying that you're weird, you're different than anybody else, or you've made a mistake, you've got the wrong reasoning. I'm saying you don't understand yourself, right? That's what I'm saying. Now, of course, I don't have to do it in quite this arrogant way that I'm doing it here, right? I try and be a bit more subtle. But I think philosophy is very interesting in this way, that it can point out to us often that we don't understand ourselves. And often, I think the most interesting part of philosophy is it is a kind of voyage of self-discovery. We discover things about ourselves, right, that we didn't understand right before. And I think when we go on to the part of the course that's not mainstream jurisprudence, that is the part of the course where we're doing how I think this course should be done, we do quite a lot of this stuff, right, where we're investigating ourselves. We're revealing things to ourselves about ourselves that we didn't realize before. It sounds a bit like psychology, but it's not, as we'll see. It's not psychology. It's not completely unrelated to psychology, but it's not the same. Anyway, okay, so people tell me that they stop at red lights because they don't want to have a crash and they don't want to get a ticket. And I say, sometimes perhaps that's true, but most of the time it's not true. And the way I reveal this to people is I say, well, look, how many times in a normal drive do you stop at a red light? You might stop, 10, 15 times at a red light. Is it really true that every time you stop, you think, oh, I must stop because if I don't stop, I'll get a ticket or I'll have a crash? And I don't think that anybody, I think you'd have, maybe I shouldn't say nobody, but I think you'd have to be a very strange person if every time you stopped at a red light, that thought process went through your mind. Right? I just don't think that happens. And why? Because you'd be too tired, right, by the time you got to your destination. Now, you might say, what? It's not that hard to think about stopping at a red light. Yes, but remember that there's all sorts of other things that you have to think about too when you're driving. Like, for example, I have to, in the country where I live, I have to think about driving on the left. Why do I drive on the left? Is it because if I don't drive on the left, I might have a crash or I might have a ticket? So I have to be thinking about that all the time too. I'm constantly thinking, I must drive on the left. All right, this would wear you down if you had to think of all of it. Don't change lanes without indicating. If I had to consciously process all this information while driving, I'd be exhausted when I got to my destination. It would be too difficult, right? And so most of the time when I stop at red lights, I just stop because red means stop. That's it, right? I just see a red light and I stop because red means stop. I don't go through this thought process of, red means that if I go through, the other cars might have a crash. No, I don't think of that. I don't think of that at all. Not never. I'm not saying I never think of it, but it's actually really rare that I think of that, right? And nor do I think if I go through the red light, there might be a police officer watching and I might get fined. It's not that I never think of that, but it's very seldom. I only ever think of that if, like, I'm driving home really late at night and, the light's gone red and I think, oh, this is pointless, there's no cars around. Then I might think about those things, right? But normally when I'm driving, I just stop at a red light because red means stop, right? I just don't, in a sense, I don't think about it at all, right? The light just goes red and I stop, right? Why do I drive on the left? Because you drive on the left in New Zealand, right? You drive on the left. That's why I drive on the left. I don't get into the car and think, oh, there's a rule that says I must drive on the left. So that, I don't do any of that. I just drive on the left because you drive on the left, right? Why do I indicate when changing lanes? Is it because I think, oh, well, I'll get a ticket if I don't, or I might cause a crash if I... No, it's just because you indicate when you change lanes. So what we're seeing here is that there are these rules. Right, there is a rule that says you must stop at a red light. There is a rule that says you must indicate when changing lanes. There is a rule that says I have to drive on the left. But I have internalized those rules. Right? I don't, at least normally, I don't experience them as a command from someone external forcing me to do things. Right? I have internalized those rules and I orient my behavior just, as it were, automatically in accordance with them. The light goes red, I stop, just because red means stop. I drive on the left without even thinking about which side of the road to drive on because I've just internalized that rule. Now, when I go to North America or Europe, then I have to make an effort, right, to drive on the other side of the road. But actually, what's quite remarkable, I find, is how quickly I internalize the new rule, right? I mean, I have to think about driving on the right for about 30 seconds. Right? And then I've internalized the rule and it becomes automatic. It wasn't like that when I first started. When I first started driving on the right, it was crazy. But now when I drive on the right, it's not an effort at all, right? So I've internalized those rules, right? And the point that Hart's making is that law is often and maybe even usually like this. Okay, it's not experienced by us as a command by someone external. It's something that we've internalized, right? And we just do it because we take it as a standard for our own conduct, right? We've taken the law as a standard for our own conduct. Okay. Right, so the law is like this. Another thing to think about here is the rules of games, right? So if I'm playing, let's just say, for example, I'm playing rugby union, and I've got the ball and I'm passing it. I pass the ball backwards, right? Now, for those who don't know, in rugby union, you're not allowed to pass the ball forwards. Okay, it's not like American football, right? You're allowed to do that once a play. You're not allowed to do this at all in rugby union. So you have to pass the ball backwards. Now, when I play rugby, I don't play anymore, but when I used to play, right, I don't think about passing and go, oh, maybe I should pass forward. Oh, no. I don't go through this thought process. If I went through that thought process, I'd be an even worse player than I was because I would take so long to pass. Right? I just automatically pass backwards. I don't even think about it because I've taken the rule against passing forwards as a standard for my own conduct. Or think of playing games like chess. Right? If I hate playing chess, or my son, my second son, Pity, always wants me to play chess for them, but he's good and I'm hopeless, so I generally refuse. But if I am playing chess, right, I don't get the rook. If I'm moving the rook, I don't think, now how should I move this rook? Should I move it on a diagonal? No, I just move it in a straight line because I know there's a rule that says rook should move in a straight line. And let's just say that I do. Imagine how odd this conversation would be. Let's say I move the rook in I'm playing chess with Piri, and I move the rook in a diagonal, and he says, you can't do that. And I say, hey, who are you to impose these obligations on me? Right? This would be a very weird conversation. This would be, I'd be a very strange person to do that. Right? Hey, it's a free country. I can move my rook in a diagonal if I want to. Right? That would be I'd be a very strange person to do that. I mean, it is a free country, right? There's no law against me moving my rook on a diagonal. I mean, in that sense. But there is a rule of the game, and if you play the game, you've internalized. Part of what it means to play chess is to have the rules of chess internalized, so that you obey the rules without even thinking about them. Right? Okay, so when I play chess, I obey the rules without experiencing the rules as a bunch of commands imposed on me by somebody else. No, I've internalized those rules, right? And I obey the rules because I've set those rules as standards for my own conduct. Okay, and law is like that too. Not always, but it is often like that. Right, and so we need a theory that can explain why the law is like that. And having a theory of law as a system of rules means that it can be explained that way. Right, so just like the rules of chess can be internalized, just the rule that says you have to stop at a red light can be internalized. Right, just as the rules of rugby union can be internalized, the rule that says I have to drive on the left can be internalized. Commands can't be internalized, right, but rules can be. Okay, all right. Now, also, and this is a point that we saw last time, rules can justify certain responses as a response to the violation of the rule. That wasn't very well put. Let me put that again. If you have a rule, right, then if someone breaks the rule, you can justify responding to that on the basis that they broke the rule. Okay, so if there's a rule that says I have to stop at red lights and I don't, you can use the fact that I violated the rule as a justification for imposing a sanction on me. Okay, and as we talked about last time, that's how courts understand what they're doing. They're not just imposing punishments on people when they, say, for example, violate the criminal law. They're not just imposing punishments on people because they have the physical power to do so, right? Because they have the political power to do it. They're imposing penalties on people because they think it's justified, and it's justified by the fact that the criminal violated the rules. And that's true in other areas of the law, such as tort law, or in the bits of contract that deal with breach of contract and so on. Okay, so we can distinguish here between what we could call primary rules, that is, rules that tell us what to do or what not to do, and other rules, sort of what we could call secondary rules. So this would be, for example, rules about what to do when someone has violated the primary rules. And Hart makes a lot of this distinction between primary and secondary rules. And here's a slide to explore that idea. Okay, so we have primary rules, which are the rules that command, and we have secondary rules that are the rules about the primary rules. Okay, so the primary rules are the rules that actually tell us what to do and what not to do, and the secondary rules are rules about the primary rules, all right? And this is very important because there's no room for this on the theory of classical positivism. There's no room for any secondary rules. But Hart says a lot of law is actually some law is about rules telling us what to do and what not to do, but a lot of law is rules about those rules, right? There's a lot of, if you go to law school, you spend a lot of time, yes, most of the time, in a way, really, you're studying rules about the rules rather than rules that tell people how to behave. Okay, and Hart distinguished between three kinds of secondary rules, as you can see on the slide. I'll switch back to that. Rules of change, rules of adjudication, and rules of recognition. Rather, the rule of recognition. So let's go through these in turn. So one of the important secondary rules in a mature legal system are rules about how to change the rules, right? So we all know that the law can be changed, right? But it's not just that the law can be changed. There's a law about how to change the law, right? So there are legal rules about how the legal rules can be changed. Okay, so their rules have changed. So, for example, there are rules about, so there are statutes, right? And now in my jurisdiction, there are rules about how to create statutes. Okay, so there has to be a bill that goes through Parliament. I mean, when you study public law, you study all of this. I won't go through all of the detail, but a bill has to be passed in Parliament and then receive the assent of the Governor-General. That's the position. Of course, it's in other jurisdictions, it's a different story, but they're similar, but different stories. Okay, so and those rules are not mere political conventions. They are legal rules, all right? And the law is that if those rules aren't followed, then the statute isn't a statute, right? And there are also, in federal jurisdiction, there are rules about the area in which a particular legislature can legislate. So in Canada, for example, there's a legal rule that says that the provincial legislatures cannot make criminal law, right? Whereas the federal legislature cannot make rules that relate to licensing at a local level or whatever I've forgotten the terms of the language of the Constitution. There was a long time ago. I studied law in Canada, but it was a long time ago. But so there are rules about how you make law, and there are rules about which bodies can make the law. So in Canada, licensing laws there's a law that says that licensing laws can be made only by the provincial legislatures, and criminal law can only be made by the federal legislature, by the federal parliament. There's a law that says that. Okay, and a lot of what's important to lawyers are these kinds of laws about the law, right, rather than laws about how people should behave. And it's not only laws about creating law, but laws about changing law. So there's laws about how you change statutes, right? So if there's a statute that you want to abrogate, you want to remove a statute, right, there are rules about how you do that. There are rules about how you interpret statutes. What do you do if two statutes are inconsistent with each other, right? There's a law about that, right? So there's law about law, right? And there's no place for this in the theory of classical positivism, but there is a place for it in the theory of modern positivism, right? Because once we start understanding the law as a system of rules, we can distinguish between primary rules and secondary rules, and we can say that a significant part of the law is about the secondary rules, right? There's law about law. We can explain that. Okay, so that rules have changed. Rules about how to, basically it should be rules about rules of creation and change, rules about how to create law, and laws about how to change the law. Okay, all right. So there are lots of those rules within a legal system. Let's move on then to rules of adjudication. So, with respect to rules of adjudication, there are lots of rules in a legal system about the application of the other rules. Okay, so for example, in a legal system, disputes might arise as to whether the primary rules have been violated. Remember, primary rules are rules that tell us what to do. Okay, so there might be a dispute about whether a primary rule has been violated, and there has to be some procedure to work out whether the rule was violated. And you know, the basic procedure that we have in our legal systems are courts. I mean, we have courts to do this. That's their job. And now there are rules. There is law about how the courts should behave, right? We call that the law of civil and criminal procedure, right? So mostly. There's also the law of evidence, which is also law about rules about what the court is entitled to rely on when judging whether a primary rule has been violated. Okay? And these rules are also very important to lawyers, right? So there has to be, the primary rules have to be applied, and there are going to be lots of rules about the application of those rules. So we can call those rules of adjudication. Rules that tell courts and others how they should adjudicate whether the primary rules have been obeyed or broken. Okay, and those rules are very important, right? Rules of adjudication are very important. They include the laws of civil procedure, the laws of criminal procedure, the laws of evidence, and so on. Okay, and then the key one for Hart, and the one that attracts the most philosophical interest, although we're not going to spend a lot of time talking about it now, we may come back to it later, is the rule of recognition. And this is Hart's idea that there is a rule, a master rule, in any legal system. It may be a very complicated thing, and it may be almost impossible, maybe actually practically impossible to state it in all its detail. But there must, at least in principle, be a general rule that is used to work out what is law and what isn't. Okay, and it's called the rule of recognition because the idea is that we use this rule to work out which rules in a society are laws and which rules aren't. Okay, so we know, for example, that in my jurisdiction there's a thing called the Crimes Act, 1961. I think it's 90. I'm not a criminal lawyer, right? So if you're a criminal lawyer, you'd have the date of this act burned into your brain. I think it's 1961. Anyway, who cares? There's this thing called the Crimes Act, right? And we know the Crimes Act contains a whole lot of rules, right? We know those rules are laws, right? Those rules are laws, right? Now, on the other hand, right, there are a bunch of rules that are applied in my workplace. So, for example, if you use a coffee cup, after you've finished with it, you're supposed to put it in the dishwasher and not just leave it on the bench. Right? That's a rule too, but we know that's not a law. But now the question that Hart asks himself is, well, how do we know that? How do we know that the stuff in the Crimes Act, those rules in the Crimes Act, are laws, but the rules in my workplace are not laws? How do we know that? And his answer is, well, there must be a rule that tells us which rules are laws and which rules are not laws. Okay, there must, and what are we going to call this rule? Well, let's just call it the rule of recognition. It's the rule that we use to recognize which rules are laws and which rules are not laws. And that's the kind of, if you like, the master rule of a legal system. Now, as I say, that rule might be very complicated. It might even be, for practical purposes, impossible to state in all its detail and all its complexity, right? But there must be such a thing. And how do we know that there must be such a thing? Because if you look and you see, you can see people using it, right? For example, judges do distinguish between what's law and what's not law, and so they must be using the rule of recognition to do so, says Hart. Now, it may be that no individual judge could ever give a complete statement of the rule of recognition, but they, in all its detail, because it's just too complicated and it's too hazy in certain areas and so on. But nevertheless, judges do use that rule. I mean, if I go to court suing you on the basis that you didn't put your coffee cup in the dishwasher, I won't succeed. The court will say that's not a law, right? The court will use this rule that distinguishes between what's law and what's not law, right? It will use that law that distinguishes between what's law and what's not law in order to determine the result, in order to find against me. Okay, so here are three kinds of secondary rules. There's rules of change, the rules of adjudication, and rules of recognition. None of those can be captured by classical positivism because it focuses on the idea of command. But because Hart's theory is based on the idea of rules, it can account for all of those things. So that's all fine. Okay, now that's all I want to say about Hart's theory now. It may be that in later episodes we'll come back to visit parts of it, particularly the idea of a rule of recognition, because that's going to be important, because I think there's a problem with it that relates to what we're going to talk about later. So we'll come back to it. But that's Hart's theory in a nutshell, and that will do for our purposes. I mean, of course, if you want to pursue this idea in more detail, there must be heaps of other stuff on YouTube about it, or maybe I could make some episodes later about it. But I think that's all we need. All we need to know for the purposes of this series. Okay, But what I want to do now is I want to do something that ideally I would do in a separate episode, but it's not going to be long enough to justify being in a separate episode. It either has to be too short to be a separate episode or so long that it would be 5 or 6 episodes. And I really want to get on to the second and third parts of the course, which is what I think is wrong with mainstream jurisprudence and how I think it should be done. Okay, so I'm tacking this little bit on at the end, which is, why do people think there's a problem with modern positivism? If it seems to be such an improvement, and it is on the face of it, right? So a big improvement on classical positivism, why do people think that it's not an adequate theory? And the answer to this question is to go back to the beginning of what we've been talking about. What was the central insight that the modern positivists had? It was that law is not simply a matter of force. It's not simply do it or else, but law contains deontic power. It is a matter of rights, duties, powers, permissions, and all of that stuff. Okay, and so far we've looked at Hart's theory, right? We've looked at it in a nutshell. Okay, what part of Hart's theory explains the law's deontic power? What part of Hart's theory explains why law creates rights, duties, powers, permissions, and so forth? And the answer is there is no explanation for that in Hart's theory. And this is one of the curious things about Hart. And I have to say, I guess it's probably best to be honest. I mean, in a way, it might be technically better for me not to say this. But I think this is not just a serious problem with the theory, but it must really reflect very negatively. It should reflect very negatively on how one thinks about Hart as a philosopher, because Hart rejects classical positivism because he says it can't explain this absolutely central thing about law, and then he presents a theory that can't explain it either. And there's not even really any attempt in his theory to explain it. And I think that's not just a small mistake. That's very, very serious error. Now, I say this because for most people in the English-speaking world, and that writer is important, for most people in the English-speaking world, Hart is a great... most philosophers of law in the English-speaking world, Hart is a great philosopher. I just don't think he is. I think he had some really important insights for the reasons that we've seen, but he is not one of the great philosophers at all. And one of the reasons I think this is because I don't think, if you identify a really significant problem with someone else's theory, you really have to come up with a theory, at least try to explain that thing in your own theory. But Hart doesn't even try, really, right? He has no explanation for the thing that he thinks is so central to law that it's the base, the core of his rejection of classical positivism. I mean, the fact that the law is a system of rules can't explain why I have any rights, duties, powers, and permissions, and so on. Think about it the other way. So Hart's saying that if the law says you have to pay tax, you have a legal obligation to pay tax. The mere fact that the law consists of rules can't explain that. I can't impose obligations on you just by making up some rules, right? I mean, if I just make up a rule that says you have to pay me $1,000 in tax, that doesn't create any obligation in you to give me any money, right? So where's the explanation in Hart for the fact that the law has deontic power? There is no explanation in his theory, and that is a howler, right? Given that he used that as his battering ram to smash classical positivism, right? So I can't hide the fact, I don't think it's proper to hide the fact that I think this is a very serious blot on Hart's legacy. I also think that that Hart, although he had some important insights, there's a seriously undeveloped theory here. And I'll talk more about that next time when I talk about what I think is wrong with modern positivism. The key of all, the point of all of this is not to criticize Hart for the sake of having a go at him. The point is that to connect with something I'm going to say in the next episode, modern, is at least in the English-speaking world, modern philosophy of law is obsessed with a figure who was not nearly as great as we think he was, right? And because of this obsession, we're unable to move on, and we just need to move on. Hart didn't, I'm not saying he got everything wrong. He didn't get everything wrong. He got some things really right, and that's important, but we need to move on, right? He's not the full stop, the period at the end of investigation into law. He's not that important. He's not that good, right? We need to, he was a significant, he made some significant contributions, and we need to learn from them and move on, right? But we won't move on while we treat him as some kind of paragon of philosophy, which he is not. And I might just add now that I don't think any person who's not a philosopher of law thinks that Hart is a great philosopher. In fact, when I studied philosophy as an undergraduate, and I think in maybe even till the end of my PhD, I never really came across Hart, right, at all. It just wasn't significant. Now, of course, if I'd studied legal philosophy as part of my philosophy degree, I would have come across Hart. But, most philosophers don't know anything about Hart. And also, if you're not, and remember I've been saying, if you're an English-speaking philosopher of law, then Hart's this paragon. But if you're not an English-speaking philosopher of law, Hart doesn't have this reputation either. It's certainly if you're a German-speaking philosopher of law, you think that Kelsen is a much greater philosopher than Hart, and he was a much greater philosopher than Hart. That doesn't mean that Kelsen is right. It doesn't mean that Kelsen is more correct than Hart. But the philosophical depth of Kelsen is just orders of magnitude greater than Hart. I don't say this because I want to have a go at Hart. What's the point? The guy's dead. I mean, and I want him to be well thought of because he made some important contributions. The problem is, I think that it is not his fault, right? That it's our fault, not his fault. But the problem is that Hart is preventing us. The veneration of Hart is preventing us from moving on as a discipline, and that has to stop. Hart is not Kant, right? People actually moved on quite quickly from Kant, and Kant was a genuinely great philosopher. Right? Hart is not in that league, and we need to learn what we can from Hart and move on. Anyway, some people who want to move on, I will just deal with now quite quickly, right? Because this is the bit where you either talk about them for a couple of minutes or you talk about these guys for 6 hours, and I just want it to be a couple of minutes. There are a bunch of people who would say, look, the problem with Hart's theory is exactly what Alan has just told you. The fundamental problem with Hart's theory is that it says that law must carry rights, duties, powers, permissions, obligations. That law has deontic power, but it can't explain it, right? And we need to be able to explain it. And here's the thing: the only way that we could explain how law creates rights, duties, powers, permissions, and so on is to understand that law is essentially connected with morality, right? Hence the natural lawyers. And here are 3 key figures from that movement. Okay, so we have Lon Fuller on the left, who was a professor at Harvard. We have John Finnis, who's is at Oxford, and Ronald Dworkin, who was also at Oxford. Okay, and these are 3 leading natural lawyers. Now, as I said in the first episode, it's controversial whether you should call some of these guys, particularly Dworkin, a natural lawyer, but I don't want to worry about that. For our purposes, they're natural lawyers. They're all people who say there is an essential connection between law and morality, and the positivists were wrong to deny that there is an absolute distinction between the way the law is and the way the law ought to be. There is a distinction between the way the law is and the way that it ought to be, but it's not nearly as deep, it's not nearly as hard and fast as the positivists claim. There is an essential connection between law and morality. Now, I think these guys' views are really, really interesting and really worth pursuing. And the reason I'm going to ignore them here is not because I think that they're worth, that they're not worth investigating. They are definitely worth investigating. I do plan to discuss their views later, because what I want to do is, instead of discussing their views on their own and then explaining what I think is wrong with them and then doing all of that, what I'm going to do is I'm going to, in the next episode, move on to what I think is wrong with the whole of mainstream jurisprudence, and then do how I think it should be done, and then bring these guys in then, because I think there is a way of understanding their views that once you free it from this debate between positivism and natural law theory, once you free their views from that debate, right, we can see that they're making a really important contribution to our understanding of law. It's just that the debate between positivism and natural law theory is misleading us about the significance, the importance of what these guys are saying. So I'm definitely not saying these guys are unimportant. I'm just putting them on hold. We'll come back to them later. Next time, what I think is wrong with mainstream jurisprudence. Thanks again. Thanks very much for watching.